very important question has arisen, and that is what is I feel also troubling the lordships a little, that at the time of hearing before the High Court, the state authorities took a stand that there could be more. And that is something which is a little disturbing. I was also feeling how to answer that. Problem lies is very simple, Lord. For the state to admit that this much has happened is an admission that something wrong has happened. They could not, at least in the preliminary stages of the hearing. Now, of course, they have now taken a very clear, candid stand. But at the preliminary stages of hearing, to say that yes, this much has happened is an admission that yes, I have done something wrong. They could not have said that I've done something wrong. So they just wipe their hand off by saying that we don't know, we don't know. That we don't know doesn't mean, not that, one second. We don't know doesn't mean that, we don't know doesn't mean, just last word, Lord. We don't know doesn't mean that there could be other methods of wrongdoing.
But 2 seconds, I took 3 seconds earlier. Okay. 2 paragraphs, in total 5 seconds. 2 paragraphs, my lords, which will clear lordships all doubts about the authenticity of the data and the hash value. Please note those paragraphs, that's all. Para 305, 289, one more thing, just one more thing, Millers, just one more thing. In the concluding paragraphs, when you direct custodial interrogation of those tainted, how is it possible that you say that it cannot be segregated? We left our government jobs. The only prayer, as my learned colleague requested me to put it to my lords, was that do not cancel the selection was not the prayer. The second thing is we left government jobs to come to my lords. And the last thing, without taking more time, my lords, is that permit me written submissions to point out those paragraphs.
Well, just 2 points, my lords. Just 2 points. I represent untainted Group A and Group B teachers who've been teaching for the last 6 years. In our groups, the CBI has found only 8.5 and 14.4% to be tainted or irregular. What is the way forward for people like us who are a majority of these candidates who have been teaching in the state? The way forward is in Inderjeet Singh Kehlon, your lordships in 2006 said only if a majority of the candidates are tainted should you set aside the whole process. That is not the case here. Secondly, in Vanshika last year, your lordships sitting in 3 judges said very clearly that you must segregate because your response must be proportionate. If your response is to set aside the entire process, it is disproportionate and it is injustice to a majority of Group A and Group B teachers who have been teaching in the state.
Grateful, Millard. Couple of figures, Millard, I would like to point out, Millard. The total number of vacancies for class 9 and 10 was 12,905. The total number of vacancy as advertised in 11 and 12 were 5,712. The total applicant for 9 and 10 was 1,41,000 and odd, Millard, and for 11 and 12, Millard, was 1,50,000, Millard. There were first 2 writ petitions, Millard, that were filed. One is Setabuddin, Millard, and the other one is, Millard, Soma Sinha. Millard, the Soma Sinha was discontinued, Millard. Ours were the 3rd writ petition, Millard. We were the original whistleblowers, and Lordship will kindly take, Millard, one order passed in our matter, Millard, that would appear, Millard, at page 602 to 604 of our compilation, Millard.
Yes.
Here, Millard, a detailed order was passed, Millard, wherein, Millard, Lordship will kindly take... I'm sorry, Millard.
602 of which volume?
602 of, Millard, this is volume 4, Millard. I'm sorry, Millard.
Yes.
Millard, here, Millard, a detailed, Lordship will kindly take, Millard, internal page 2, Millard, where, I'm sorry, Millard, it's volume 3, Millard. I'm sorry, I'm a bit confused with so many volumes, Millard. I have just made quick notes, Millard. I'm extremely sorry, Millard. Dr. Patro, Senior Counsel for the Commission, also files a report in the form of an affidavit wherein the manipulation of the marks in the OMR sheets of the above named candidates has been alleged. Let it also be kept on record. I'm reading from internal page 2 of that order, Millard, at page 603.
Please read it again.
Yes, Millard. Lordship will kindly take, Millard.
What is the date of this order?
This order is of 2nd of February 2023, Millard. This was the order, Millard. I may not, Millard, I will only point out the paragraph once, Millard. That is, my lord, Dr. Pathrod, learned counsel for the commission, also files a report in the form of an affidavit wherein the manipulation of marks in the OMR sheet of the above named candidates has been alleged. Let it be kept on record. Thereafter, my lord, Dr. Patro submits that the recommendation of the above named candidates were erroneous, my lord. So there's an express admission with regard to that. Coming thereafter, my lord, on the basis of this order, my lord, there was a subsequent order that was passed, my lord, on 8th of February 2023, my lord.
Yes.
Page 605. These are here, my lord, on the 2nd of February's order was quoted on the very first paragraph, Lordship will find, my lord. This quote by the order dated 2nd of February directed the commission to file an affidavit disclosing the modalities to be adopted by the commission in exercise of the powers under Rule 17, my lord. Pausing here for a moment, my lord, what does Rule 17 speaks of, my lord? Rule 17, time and again, all my lord colleagues, my lord, have cited, my lord. Rule 17 empowers the commission, my lord, to, my lord, withhold on withdraw or rescind any recommendation that has been made, my lord. The power is vested exclusively with the commission. Now, my submission with this regard is the moment the commission exercises the power under 17, it sets the clock back to where it was originally. That is, my lord, at the time of 12.6, which my lord friend Miss Makija was referring to, my lord, with regard to publication of panel and etc. The moment, my lord, some of the people have been taken out where there is an express admission with regard to erroneous inclusion in the list and 17 is applied, my lord, we actually do a time travel, my lord. We actually go back and start the process afresh under 12.6, my lord. One more line, my lord. I have 40 seconds, my lord. I will conclude, my lord. For the period of 9 years, my lord, people who have applied and who are not called for verification, my lord, they would be inured to the benefit of their service period, my lord. They have lost everything, my lord. They tried, my lord, all ends up, my lord. They tried to get into the...
I have prepared a note. I have just prepared 1-page note. I just want to say one line. Because we are those who are working from 1999 and we were confined to one zone. Thereafter, we got an opportunity to go and to do it centralized posting. So we got centralized posting. We were selected. We are not in the tainted list and we got our pay scale the same as what was there before. Pay protection, provident fund protection, service protection. So everything was protected.
1 minute.
So therefore, my lord, I am only...
Division bench.
So there, my case is sui generis, my lord, in that sense, that it has nothing to do with the...
Division bench.
I'm much obliged.
This court, while remanding, told the High Court to assess, my lord, the admissibility of the scanned OMR. That's the principal question. The matter was referred to CFSL, Kolkata. That's a part of the order which I had read. Kolkata, my lord, after Hyderabad refused, went to Kolkata. Kolkata is still not examined. The High Court has still given a finding about, my lord, the admissibility, my lord, number one. Number two, the only other way, my lord, to find out of whether it is tampered, one is CFSL, the other is hash value. So if you have the original hash value, every time there is some tampering, the hash value changes, right? But my lord, here, unfortunately, original hash value was not taken. If you don't get the starting line, you can't go, my lord, to the next line. Therefore, my lord, the High Court committed a gross error in ultimately saying that we accept the certificate of Pankaj Bansal, notwithstanding 65B may not be, may not followed, but we rely on Section 3 and Section 58 of the Evidence Act to accept his OMR, notwithstanding, my lord, that Pankaj Bansal was nobody to keep, my lord, the hard disk. There is one more hard disk from Niladri Das, which has surfaced. There is one CD, my lord, which is missing, untraceable. In the face of, this is stated in the charge sheet. In the face of this, how do you, my lord, segregate from one from the other? As far as I am concerned, this is not enough to knock out.
Your Lordship may permit me.
No, there's one point of the state.
Your Lordship may permit me. Your Lordship may permit me for untainted candidates, my lord. This is 1-page note. Your Lordship may have it. No, my note is here, my lord.
Half a minute, my lord.
My lord, my note is here. Just 1 minute. My note is here, my lord. If your lordship may have it, my lord.
Yes.
My submission is, my lord, your lordship may accept the investigation that have been taken place till now as it is. We are untainted. We left the earlier employment and joined here, and through all the scrutiny, we are still untainted. My lord, your lordship, just see page 1. There are 3 categories. I'll just quickly in 1 minute sum up this, my lord. There are 3 categories according to me, my lord. This is one is OMR mismatch. Second is rank jump and out of panel. And third is excess appointment. As far as first 2 categories are concerned, your lordship may see the box. In the first category, I have given all the paginations where this list is there. Your lordship may turn the page. For the second category, the list is there. As far as the third category is concerned, which is excess appointment from the panel, this comes out of para 271 of the judgment. Now CBI or somebody has coined this excess appointment 1539. The list is not there. What is the basis? That is also not there. Now, your lordship may just read this with me, my lord, this about this 1539 and 199. This is the source of this figure in para 271 of the impugned judgment of the Honorable Court. From the record, we do not find that the CBI has given the data or they have found excess appointment of teaching categories. CBI states that they will provide the details of individual candidates who received appointment illegally as mentioned in different tables set out in written submission, see para 12 of volume 6. All the appointees have recommendations subject to clarification by CBI. There is possibility that these sets of person may fall in earlier categories like OMR number mismatch, rank jump, out of panel. Hence, this number could be hypothetical. This is my submission, my lord. Last one is, my lord, that there is a portal of a state government. On that portal, all the details of all the appointed candidates are there. And there is no single appointment which is without recommendation of the commission. That's how I have been instructed.
Okay.
Last thing, my lord. Because we have left our appointments, my lord, earlier employment, my lord. We are in the middle of our ages, my lord. We have children, my lord. Your lordship may apply the principle of segregation and protect those who are untainted and innocent.
Yes, please.
Lordship, most important point I have to bring on the record. Lordship, the main petitioner, BAISHAKHI BHATTACHARYYA, she is at now 54. She is not bona fide candidate. She is now at 54 age. At the time of examination, she was 48.
Just 30 seconds.
Lordship, and other my points are given in there.
Okay, fine.
I'll detail.
Lord, I am giving 2 judgments here where my lords have held, my lord, this court has laid down that in the case where there are 2 categories, illegal appointed and properly appointed, then if there is a possibility of segregation.
Taffy away, please.
There is.
Did not argue on that.
I have only one sentence. I have
One sentence. Integrity of the process we come back to as the basic question, my lords. 3 judges bench in Anwar's case.
Taffy,
paragraph 20.
I have one sentence, my lord. There is one side is the dishonest candidates, other side the honest candidates, and there is SSC and the state. And all
Lord, just
add one line ensure
Lord, just 30
so that my lord,
seconds,
the
Lord.
innocent,
I pick
honest
one line.
candidates, my lord, they do not lose.
Okay, fine.
They are
Lord,
trust in the system.
Just 30 seconds. Lord.
Lines. Lord, I'm in the category of the untainted, and we say that we should be segregated, which I therefore adopt the arguments of Dr. Singhvi and others. Just one thing, I'm just handing over a note. There are at least, according to our calculations, Lord, 20,000 people who appeared, who have given up their jobs, etc., and come in. And for instance, Lord, clerical staff, Lord, assistant teacher.
Lord, just
Now only the state council.
yes, Lord, just 30 seconds. I just want to say one thing, my lord.
I am appearing
Lord,
from
just
day
30 seconds only.
I am appearing
Lord, I
from the
beg to
petitioners
appeal
from
for
day
one
one.
peaceful candidate.
May I just point out?
Look, we will not be able
Lord,
to.
just 30 seconds only.
May I just point out the things, submissions which have been made by the CBI are totally contrary to the records. Today, for the first time, the CBI has handed over and said Following the inspection, no candidate disputed the authenticity OMR images shown to them, asserting that they are not theirs. Now, my lord, specifically, there is a affidavit to that effect. My lord, kindly comes to page 656. Well, yeah, just
10 seconds. Just 10 seconds.
Lord, give me just one line. Just one line.
Just 10
Their
seconds.
admissions are, my lord,
We'll have to.
just
One line. Just 10 seconds.
if I just kindly point out the affidavit, my lord.
Please sit down. We have audio.
May I show only one paragraph, my lord? Only one paragraph. How the DB reached to the authenticity, my lord, 308, only one paragraph.
Please, we have gone through. We have heard you.
Lord, just
Well,
10
one-
seconds.
one
Lord.
line
Lord,
can
just
I-
10 seconds.
That's all.
Lord, just
One
10
line.
seconds, my lord. Lord, I beg to appear for the wait-listed candidates. My lord, there is an issue as far as, my lord, appointment of these wait-listed candidates to supernumerary posts is concerned, which is pending in the High Court, my lord. And that writ petition, my lord, is 25056.
We
my
know
lord.
about
And ultimately, my lord, just one more thing, my lord.
Lord,
Lord, we have
Lord, may I point out a logic,
Lord,
a logical infirmity in the judge's, in the impugned order. Lord, paragraph 240. Lord, the judge, the division bench segregates and says these are unduly high percentages. Lord, segregation is by perforce possible. Lord, I would urge your lordship to make.
Lordship, permit me one sentence.
No
Lordship,
more.
please permit
That's
one
all.
sentence.
That's all.
I promise I will not repeat what has been stated. There are 3 hard disks. The first one, there is no hash value. And the entire data which Pankaj Bansal and Scantech, which has been come out and they're talking about been genuine, is from that hard disk, which there is no hash value. Even in the 65B, para number 285. The first one does not have a hash value. And the entire data, it like comes out of a PC Sarkar magic show. The entire thing comes out and says, yes, Pankaj Bansal data is correct, so is Scantech. That the entire thing comes out from one hard disk, which does not have a hash value. That's it.
May I just add one line? May I just add one line?
Can I
Please, that's over.
one submission?
We have to bring it to.
One submission, my lord,
We have
on
to
behalf
bring
of
this to
untainted
closure.
candidates.
Please, Mr.
My lord,
Trivedi.
one submission, my lord,
Yes.
kindly consider
Lord,
page
kindly-
553 of
No more, please. That's all.
Kindly have page 161.
Honorable High Court records that the
Yes, please, Mr. Trivedi.
there is a clear data. Lord, one sir.
That's all, please.
Well, there's one line can I add?
Leader may be just unmuted for a minute. He wants to make one submission on our behalf in item
Well, I'm
4.3.
appearing for 18 blind teachers, my lord. And they were already in service. They took these exams for promotion. They're in the untainted lot. They're 18 blind teachers. One of them has been given benefit by the High Court at paras 360 to 362. We're asking for parity of treatment with that person with disability. These are 18 blind teachers who were already in service.
Why did you not ask the High Court itself for the same relief?
Well, we were not made parties. We were not aware. We were not aware. We were not parties, my lords. That's how we did not realize that our appointments are going to get cancelled.
And Lordship, the retention period of 1 year, I just wanted to show pages 355 and 376 of volume 5. It is the standard practice for the retention period only to be of 1 year. So nothing that SSC was doing was uncommon. Secondly, if we may be given a chance to show subject-wise segregation.
No, that's not possible.
Subjects and
That's not
0%.
No, that's all, please. Yes, Mr. Trivedi.
So-
Mr. Muralidhar, just
Yes.
give us the detailed names of those 18 candidates.
I'll do that. I'll do that.
We are aware of that argument, Mr. Bala, we are aware of that argument.
I just make
Yes, Mr. Trivedi, that's all.
just one submission before the government council. The submission is essentially this, that your lordships having heard the state council now and the state agencies, it's quite possible to go ahead with segregation. Now, if that is the case, my lords, on a principle, I mean, proportionality was canvassed. Just consider the situation of persons in service for 7 years, 10,000 teachers untainted whom I represent. So I would urge your lordships, my lords, balancing. So I think it's possibly a duty for constitutional court that where segregation is possible, to apply that rule. Unless it's completely impossible. It appears here to be possible. I'm grateful.
While adopting Mr. Diwan's argument, my lord.
Please, no more. That's it. No more.
On the last
Yes.
occasion, the lordships put one question to the state to answer, Lord. That was regarding the observation in the High Court judgment that there is widespread, state has accepted that there is widespread, Lord. I only to say this, Lord, that There have been irregularities, Lord. There's no difficulty on that, Lord. We accept that position, but widespread only means, Lord, that 50% and virtually faults were found, Lord, with regard to Group C and Group D, Lord, by Justice Bag's committee by that time, Lord. And 10%, Lord, as the Lordship saw the percentages. So therefore, what we mean by accepting widespread, Lord, is that only and nothing more than that. It doesn't mean, Lord, that there is something more.
Argument, sir, judgment reserved.
No, Lord, there is one. The point which remains.
Our written notes now. There's this one.
Lord, I have something else.
Lord, I'm for the board.
And other. Sorry, please. The point which your Lordships reserved for me, Lord, is regarding entirely different. That is regarding CBI investigation, which your Lordship said I'll hear later on, Lord.
That point will be taken up
Lord, our written notes are some.
That 1 minute, please. That is with regard to the supernumerary force.
The order which we passed, which expressly mentions at page 368 that it is subject to the orders passed by the High Court. Number one. Number two, Lord, there is in the petitions which have been decided, none of the petitions challenge the government order.
How could you challenge?
Number three, Lord, there is another petition pending, which is writ petition 25056 of 22, where, Lord, specifically this order was challenged and it was stayed. So no appointment has been made, Lord, pursuant to that government order. The next aspect is, Lord, that the reason for issuing the order was that since, Lord, certain infirmities had been found, therefore, Lord, we said that subject to the orders passed by the High Court, from the wait list, it doesn't say illegal. The order says at page 368 that from the wait list, Lord, will be appointing, Lord, because there are so many large number of teachers who are going out, Lord. If all of them go out, Lord, the whole education system will fall there. So therefore, Lord, we left it to the High Court that if, Lord, something which is fault, we can accommodate.
That's my point also, my lord.
That needs to be-
We have exams which end. We have exams which end in April. Results come in May, my lord. Your lordship may take.
Submissions